as I did with the first panel. Our first paper presenter is Jonathan Green, who's an associate professor of law at the Sandra Day O'Connor College of Law at Arizona State, at least for now. Professor Green earned his JD from Yale and his PhD in history from Cambridge. He served as a Bigelow Fellow at Chicago before joining Arizona State. Professor Green will be presenting some traditional questions about history and tradition. Our second paper is from Professor Ryan Snyder, who is an associate professor of law at the University of Missouri School of Law, where his work focuses on administrative law and statutory interpretation. Before joining Mizzou, he served as a law clerk to Chief Justice John G. Roberts Jr. and Judge Kethledge of the Sixth Circuit. He served as a Bristow Fellow in the Solicitor General's office, and Professor Snyder will be presenting historical practice at the founding. Commenting on both Professor Green's and Professor Snyder's work is Keith Whittington, who's at least, 40% Richard Epstein. He is also the David Boies Professor of Law at Yale Law School. Professor Whittington is one of the foremost authorities on constitutional theory, American and political constitutional history in the nation. He joined Yale after spending most of his career at Princeton, where he was the William Nelson Cromwell Professor of Politics. Last but certainly not least is a project from Katherine Mims Crocker, who is a professor of law at Texas A&M University School of Law. She also serves as the co-director of the Center on the Structural Constitution. Before joining Texas A&M, Professor Crocker was professor William and Mary Law School. She served as a law clerk to Justice Scalia and Judge Wilkinson on the Fourth Circuit. Professor Crocker will be presenting Ex Parte Young Redux. Commenting on Professor Crocker's project is John Harrison, who is the James Madison Distinguished Professor of Law and the class of 1941 Research Professor of Law at the University of Virginia School of Law, where he served on the faculty since 1993. Professor Harrison joined UVA Law after a distinguished career in the Justice Department, including serving as the Deputy Assistant Attorney General in the Office of Legal Counsel. He's also a perfect commentator for Professor Crocker's work. If you've read it, she cites him extensively, given his own extensive work on remedies in Ex Parte Young. So thank you to all of our panelists, especially those who pitched in here at the last minute again. And it's my pleasure to turn it over to Professor Green.
Great. Thanks, Merritt, and thanks to all of you for being here today. So like Merritt said, my paper is entitled Some Traditional Questions About History and Tradition. And as the name suggests, the piece was inspired by the Supreme Court's recent turn to tradition as a means of identifying the outer bounds of enumerated constitutional rights, like the right to keep and bear arms, most conspicuously, I think. But the court's made a similar move in the context of the right to the freedom of speech, the Confrontation Clause right, and who knows, perhaps it'll make a similar move in other contexts as well. Well, much of the commentary on the court's history and tradition jurisprudence has focused on the extent to which tradition can meaningfully constrain judicial discretion in high-profile rights cases, and or whether the court is acting in good faith in its use of this jurisprudential framework. My paper is interested in a different question. As Justice Barrett has pointed out in a series of separate writings, some of which cite Professor Whittington, it's not clear why an originalist should care about tradition. So if the Constitution's legal content is equivalent to the original meaning that its words bore when those words were ratified, then why should it matter what kinds of gun regulations or speech regulations and so forth were thought to be constitutionally permissible in the decades or even centuries after the Constitution was adopted? Well, to try and make some progress on that question, my paper returns to the relation between tradition and constitutional rights in the 17th and 18th century English courts. And more specifically, it's an attempt to reconstruct how early modern English jurists understood the relation between fundamental individual rights, written sources of law codifying those rights, and the social and political customs that were thought to constitute the common law. So I'll just give a brief overview of the argument in the time that I have left. So in the English tradition, what made a right constitutional was its historical pedigree, or rather its extra-historical pedigree, its origins in a time before recorded history. So the natural rights to life, liberty, and property were like this because they'd been around for as long as human beings had. And similarly, the so-called positive rights of Englishmen, so the familiar rights to a criminal jury, to habeas corpus, and so forth, All of those were said to have been acknowledged as law by the English state as long as anyone could remember. And because those positive rights were rights against the state, so the argument went, they must have been conditions of the state's legitimacy in the first place. That's what gave them a constitutional pedigree. They were constitutive of the state's rightful authority in the first place. But just as the sovereign had the authority to regulate natural rights in the public interest, that was the point of forming a political society in the first place on classical social contract theory, the Constitution also permitted positive fundamental rights, like the right to a jury trial, to be regulated by law. And so in both cases, when 17th or 18th century English jurists asked questions like, what does the right to a jury trial entail? How far does the natural liberty to speak freely extend? What they were really asking is, what limits has our law placed on these rights? Well, the primary mechanism through which English law set the scope of fundamental rights was thought to be custom. The customs of the English people themselves, or what Jeremy Bentham called custom in pies, and those official customs to which the people had expressly or impliedly consented. So custom on this view, as most of you will know, was seen as a kind of organic coordination device, a means by which the English people had, over many generations, placed reasonable limits on their fundamental rights in order to allow themselves to live together in a reasonably functional polity. And what's more, because custom can and does evolve over time, early modern English jurists were perfectly happy to accept that the scope of constitutional rights had likely changed over time. But because custom was a legally authorized source of law, the reality of legal change wasn't thought to present an especially potent threat to the claim that the constitutional rights of Englishmen were themselves, in some basic sense, ancient and ineliminable. Well, what about legislation? So Parliament's ability to change the common law complicated this picture, but not as much as you might think. So on the one hand, if the legislature simply chose to declare that some right was in fact law, if its statute served a kind of merely clarificatory or epistemic function, well then the scope of that right, the right that it codified, it just continued as before to track custom. So the Bill of Rights 1689, for instance, was explicitly a legislative assertion of constitutional rights that the people had enjoyed before 1689. And before 1689, those rights had been delimited by custom, and since the Bill of Rights said that it wasn't changing those rights, it didn't. They continued to be customary rights even after the statute's enactment. On the other hand, if Parliament chose to change the law through a remedial statute, so to narrow or broaden the scope of some basic right, even there, the legal content of its statute was shaped by the pre-existing law that it modified. The way that such a remedial statute was received in practice through the people's customs was often determinative of its content, and we'll hear some from Ryan about that here in a second. And at least in the 17th and early 18th centuries, the substantive presumption that Parliament wouldn't willingly introduce irrationality into the law or to enact flatly unconstitutional legislation empowered the common law judges to bend and in some cases even recast statutory language. This equitable approach to interpretation allowed the courts to hedge against the possibility that the legislature might try to curtail basic rights in flatly unconstitutional ways. Well, that English tradition formed the jurisprudential backdrop against which our own Bill of Rights was ratified. And so if the story I'm telling is right, then I think it's at least plausible that the First and Second Amendments, as originally understood, might themselves index the scope of speech rights or gun rights to post-enactment custom, or what the Supreme Court has recently been calling tradition. In other words, reading the Bill of Rights through the lens of English constitutionalism gives us, I think, prima facie evidence that the opposition between traditionalism and originalism that scholars and some of the justices have posited is overstated. So that's the main claim of the paper. I should say that in the second half of the paper, I try to tease out some of the jurisprudential complications that this traditionalistic way of thinking about the scope of fundamental rights posed for English judges, especially towards the latter half of the 18th century. And a lot of those same problems, I think not coincidentally, are cropping up in the court's current case law as well. So for instance, at what level of generality should a tradition be read? What sources is an interpreter authorized to consult in order to retrieve a tradition of regulatory practice and compare contemporary laws against that tradition? How far can a course of custom bend the language of a written statutory or constitutional provision? Those questions didn't have clear, easy answers in the latter 18th century. And as a number of contemporary scholars have pointed out, the court doesn't seem, at least not yet, to have great answers to those questions today either. So I think I'll stop there and listen to what Keith has to say. But thank you all again for being here.
Thank you.
Great, thanks. So this is really, interesting paper. I should say it begins, it opens with a historiographical debate featuring J.J. Pocock, which I totally appreciate as an opening to a paper. I don't know if law review editors will appreciate it quite to the same degree. But I think it's reflective of where the paper is headed and what it's up to, and it points to, I think, what my primary comment about the paper is. So I thought substantively, I don't have significant suggestions about modifying the paper. I thought it was very useful and interesting in what it was doing. Focuses much more on commentators on how the law develops than what we see with Ryan's paper, which we'll come to in a minute. And so it's an interesting sort of comparison between the kinds of sources being used in the two papers and what kinds of information is being extracted from those sources, which is a useful thing to see those two components to it. My primary concern about the paper, however, is whether all the pieces fit together very well. And so the core framing of the paper, the opening of the paper, and the conclusion of the paper, once we get past the J.J. Pocock, the opening of the paper and the conclusion of the paper is tied to the court's current interest in text history and tradition, and trying to think about, well, how do you think about tradition in these contexts, and the sort of debates between Kavanaugh and Barrett about how to play this out. And then that recedes into the deep background as the paper works into the real body of what it's up to, and then suddenly makes a brief reappearance at the end. And I don't think the body and the framing, opening, and conclusion connect very well. And so so one kind of option, I think, with the paper, I would suspect, is that you sort of need that framing with the current court's jurisprudence in order to sell this to law reviews. And maybe that's right, maybe it's not. I'm not an expert on what sells to law reviews by any stretch of the imagination. But maybe you need it, in which case one has to, I think, do more to work with it. And if that's true, one possibility is you just shed it. And focus on the current body of the paper, in which case you're looking more at an interdisciplinary journal like Law and History Review. Because I think the core body of the paper makes its own contributions very useful in its own terms, but right now doesn't connect very well to connecting up to helping us think about the text history and tradition stuff. So one possibility is just shed the text history and tradition, preserve the core body of the paper, frame it in those terms. How were English commentators and judges in the 17th and 18th century trying to think through tradition and the development of rights and common law principles, especially with the emergence of statutes, and what were the challenges associated with that. And that core feature of the paper, I think, is very interesting and useful, but stands on its own. I think alternatively, if you want to preserve the connection with text history and tradition, paper probably needs another section to help bridge the gap between the two, and really sort of explain, and maybe I'm just too dumb to see it, right? But to explain what the lessons really ought to be from that English history to the kinds of problems and complications the court's dealing with now, and the kinds of challenges they're going to encounter as they think through their particular application of tradition in the kind of context in which they're doing it. I just don't think the paper does enough to be very informative on that point. And so it sort of reads like a sort of interesting history, but disconnected from any implications or applications we might have to the current situation. I think, like I said, that probably is best resolved by just adding another section, maybe, that sort of tries to carry it forward and develop out that argument more explicitly and tie the pieces together a bit more. I think the other two things that may be worth thinking about is the more modest possibility is maybe just a lot more signposting all through the paper will help get there in terms of elaborating the argument and sort of pitching it more. My suspicion is signposting will not be sufficient, and so maybe it's worth thinking about the basic structure and organization of the paper. One feature of the paper now and how it's organized is it's really sort of organized around, I mean, there are conceptual problems, but it's kind of chronological in its basic structure as the English jurists are moving through this period over time and trying to think about these problems. And that tends to de-emphasize and push in the background sort of what the larger thematic and conceptual lessons are that might emerge out of that history. And I think maybe structuring it more so it highlights the conceptual problems and what they're grappling with and how do they try to solve them and what the implications of the kinds of problems they're grappling with and the kind of solutions they're reaching might be a more helpful way of structuring the paper. The final, not the final section, but the final substance section related to the English stuff highlights three different components about sort of the problem of generality, for example, and a couple of other issues that emerge that are familiar to us as well, including this problem of how to think about evolving traditions post adoption of written text and the like, so how can rights continue to develop over time, even after you have a text that fixes it to some degree. And those were very interesting issues, but it's very brief. And as they were laid out, and they feel, again, sort of disconnected from what came before. And so they're drawing out some lessons from what came before, but they're not developed enough to, I think, fully explain what the argument is or why we ought to be fully persuaded these are issues and how, to what extent they're really unresolved and what the implications are, et cetera. So one way of potentially restructuring the paper is to frame the paper more in those terms and sort of highlight, okay, here's a section about how they're struggling with the generality problem and how that's being reconceptualized over time. Or how the different approaches are to grappling with that over time, what kind of solutions they're coming up to, and how adequate are they, rather than trying to save that for 2-3 pages at the sort of late stage of the paper. So like I said, I like a lot of the content of the paper. I think the current framing I find it to not work very well, and I think that the argument, such as it is too much in the background of the paper. And I think it depends a little bit on where you really want to pitch the argument as to what the best kinds of solutions are to that. But I think maybe some expansion of the paper and some reorganization of the paper might serve you well.
John, would you like to respond?
Sure. I guess I can just say a couple brief things. So the discussion of the court's recent debates in some of the separate writings from Justices Barrett and Kavanaugh is not. It's not entirely supposed to be window dressing. That's how I got into a lot of this material, or at least was the original impetus for trying to think back to how the relationship between custom, rights, and text worked in the 17th and 18th centuries. I entirely take the point that the chronological framing of the main body of the paper might distract from some of the kind of themes that I'm attempting to explore. I guess the only apology I'd give for the way that the argument's structured currently is that I just wanted someone to explain to me how these questions worked and how they developed over time in the English tradition, and couldn't find an accessible law review length article thinking through what was a constitutional right in the English tradition, how did it relate to the common law, how did the codification of rights affect or not the status of those rights. And so I guess, yeah, the honest answer is I was writing the paper for myself as much as anyone else. I would love to expand more, I think, in the end, and kind of close the circle, close the loop a little bit more fully in terms of the contemporary upshot or implications of this way of thinking about rights for the court's current jurisprudence. I'm a little hesitant to do that, for two reasons. One is the paper's too long as it is already, which is the kind of banal reason. But the second is I don't really in the paper do anything to prove out that any of this English jurisprudence translated much across the Atlantic, or indeed that the those who authored or ratified the Bill of Rights, thought about the individual rights that were being codified as customary rights. My very strong intuition is that that's exactly what was going on, mostly because I think Judd Campbell and Jonathan Gienap and others have made that point already. But it felt a little presumptuous to sort of then just simply jump across the Atlantic, speed forward, 250 years, 240 years, however many it is, and try and draw something prescriptive from this history. But the points are all entirely well taken, and I really appreciate the suggestions. I'll have to think more about how to structure it as I revise the piece.
Thank you. Professor Snyder.
Yeah, so thank you all for being here today. I'm excited to talk about my paper, Historical Practice at the Founding, which deals with the same central tension in constitutional interpretation that Professor Green has just been talking about. So on the one hand, the Supreme Court says that it's looking for the original meaning of the Constitution, what it meant at the time that it was ratified. On the other hand, the court is often relying on post-ratification practices from political actors like Congress, the president, or state governments. And a lot of times, those post-ratification practices come long after the Constitution's ratification. And it's not immediately obvious why a practice that starts in the late 19th century or even in the 20th century tells us much of anything about what the Constitution originally meant. Some scholars have tried to close the gap between those two things by pointing to the founding. They say we should interpret the Constitution in the same way that the founders should have or would have interpreted the Constitution. And the Supreme Court appears to agree with that. To the extent that the court has explained its reliance on post-ratification practice, that's the most common explanation that the court gives. And some scholars say we should rely on these post-ratification practices even if that causes the Constitution's meaning to evolve or change over time. The most prominent theory that takes this position is known as liquidation, and it is often attributed to James Madison. But there's a problem with theories like liquidation, which is that we don't really have a lot of evidence right now about whether people at the founding accepted those theories. The court, to the extent it's looked into this question, and the scholars who have looked into this question have almost exclusively looked at what James Madison said about liquidation. And although that can be helpful, James Madison is just one founder, does not necessarily speak for all of the founders. And James Madison's views and exactly what they were, I think, are contestable. There's a conventional wisdom about what Madison thought, but it's not obviously correct. So I decided to take a different approach to trying to figure out what the founders thought about historical practice. And similar to Professor Green, I decided to start with English history and looked at how English courts used practice in the 17th and 18th centuries. And then came across the Atlantic and looked at how federal courts used practice from after the time of ratification until around the Civil War. And what I found was that courts used practice as a way of trying to discover what the original meaning of the law that they were interpreting was. So practice was not a tool that courts used to update the law or to allow it to evolve over time, but instead it was a tool that was designed to help illuminate what the original meaning was. But courts recognized that not all practice is going to serve that function. So courts developed a rigorous screening test to try to distinguish between practices that would actually shed light on the original meaning and those that would not. So I want to start a little bit just by talking about the basic idea about why courts thought practice could shed light on original meaning. Then I'll talk a little bit about the screening test and then close with what should we do with this evidence today. So the basic idea is pretty straightforward. So courts thought that contemporaneous interpreters had special insight into the original meaning. They're more likely to understand the language that's being used in the law. They're more likely to understand the purpose of the law. And when courts had contemporaneous interpretations, they were happy to look at them. But of course, the problem is that a lot of times people don't write down their contemporaneous interpretations, so you need some other way of figuring out what they thought. And courts thought that practice was a way of closing the gap. So courts presumed that people tried to comply with the law, so you could figure out how they understood the law by looking at what they did. You can see this from the way that courts talked about practice and the way that early treatises talked about practice. So courts would routinely talk about practice as an interpretation. They would use that word, that practice gave an interpretation of the law. Or another common phrase they would use is they would say that practice was actually a practical construction of the law. And treatises almost always talked about practice in the section of the treatise that deals with contemporaneous interpretation, just again illustrating this connection that they saw between practice and interpretation. But the problem, of course, is that practices can be misleading. So sometimes people act without actually thinking about whether what they're doing is unlawful, and even contemporaneous interpretations can get the law wrong. Sometimes they're biased, maybe they're just not very good at interpretation. There can be lots of reasons why they don't get the law correct. So courts developed a screening test to try to figure out which practices are actually going to do a good job of helping us figure out the original meaning and which ones are not. And courts required that practices have at least 5 qualities before they would actually rely on them as evidence of original meaning. So first of all, the practice had to start contemporaneously, shortly after the law was adopted. So courts are very consistent about this. I found more than 70 cases in the English and early federal contexts that involve practice. I have not found a single case where a court relied on a practice that did not start contemporaneously with the law's adoption. So that's the first requirement. Second, the practice has to be repeated and long-standing. So oftentimes in the English system, they're looking at practices that have gone on for centuries. And in the early federal courts, we're looking at practices that have gone on at least for decades. If a practice was sparse or short-lived, courts wouldn't consider it as evidence. Third, the practice had to be consistent over time, and it had to be uniformly accepted. So if the practice is inconsistent, if it changes over time, or if people are constantly objecting to the practice as unlawful, courts are not going to consider that practice either. Fourth, courts had to have reason to believe that everybody involved, both the people engaged in the practice, but also people who were potentially harmed by the practice, all of them had to believe that the practice was actually lawful. So, of course, courts don't always have good evidence of whether people believe that, so they resorted to different proxies. And just to simplify, if a practice had gone on for a long period of time and no one had objected to it, courts applied a rebuttable presumption that the practice was lawful, that everyone believed that the practice was lawful. And then they would look at the surrounding context to try to identify different reasons why maybe someone would engage in a practice or decline to object to a practice even though they thought it was unlawful. So courts were sensitive to that possibility. The fifth requirement was that the practice had to be a reasonable interpretation of the law. So if the practice was clearly barred by the statute, then courts wouldn't consider it. So what do we do with this founding era approach? Many scholars, as I mentioned, argue that we should follow the original methods of interpretation that courts would have applied at the founding, and the court seems to agree. And if that's true, if we should follow those original methods of interpretation, then we actually have to know what they are. And what I'm trying to do in this paper is to show how the founders actually used practice, and then the Supreme Court, should follow those methods. The court actually does a pretty good job of that for the most part, but it's deviated from the founding era approach in various ways. And in particular, one of those ways is that the court often relies on practice that starts long after the Constitution's ratification, so sometimes 50 100, even 150 years after the Constitution's ratification. This evidence of the founding era approach also poses a serious challenge to the theory of liquidation, which has become very popular among the court and originalist scholars. So liquidation thinks about practice much like judicial precedent. It's basically a compromise between original meaning and stability. It does not use practice as a way of actually identifying the original meaning. And there's really just no founding era evidence that courts thought about practice in those terms. Out of the 70 so cases that I looked at, I really only managed to find one. It was an English case from 1712, where the court seemed to elevate a practice above original meaning. So there's just no real evidence that that is how courts used practice. One final point, this founding era approach is not necessarily the approach that I would come up with myself if I were starting from first principles. But if we're going to justify our use of practice by saying we have to do what the founders did, then I think we have to know what the founders did. And that's what my paper tries to do. So thank you very much and look forward to the feedback.
Thank you. Professor Whittington?
Yeah, so I think both these papers together are quite interesting and useful, and they're reflective of the fact that the court's jurisprudence can sometimes spur really new scholarship and force us to look at materials and sources that we don't tend to look at, and in a way that we have tended not to look at. And so both these papers, I think, are quite original in doing so and really do make valuable contributions in bringing to the fore a set of materials that otherwise we simply haven't thought very much about, and have done so, I think, in quite useful ways. Ryan's paper, I think, is much more focused on actually trying to give something that's going to be immediately applicable to the court as it's thinking about tradition, as it's structured, because it's framed in terms of what's the early methods that the courts were using, both in the United States, but also building on a British tradition for interpreting text. And so can we just import that as we think about sort of original methods as such? And so it gets some real traction there, which courts may well find useful in various ways. One thing I was struck by, so this paper is very focused on thinking about how courts are talking about practice in particular, and how they're talking about this thing that's now labeled as liquidation. Again, as I said this morning, not a big fan in general of this concept as such. But I think you'd find very similar things in Congress. There's similar kinds of discussions about how to think about these early precedents and practices, what kind of weight should they have, what kind of insights should they provide, about the meaning of the Constitution. So I don't think this is a uniquely judicial practice that we're discovering here, but I think is instead a more common sort of feature about how people are thinking about how do we go about understanding and working with a constitutional system more generally. One thing that would be interesting, not for this paper, is to what degree are those discussions notably different than the ways in which courts want to use this, or courts being distinctive about how they talk about practice compared to non-judicial actors. But it's striking when one thing that's useful about this paper is highlighting this sort of, it's characterized in the paper as a filtering process for trying to think about here's what practice can tell you, here's what counts as practice that we're going to make use of. And I think that's a useful way of trying to pin this down to some degree that's fairly specific. And I have 2 points about that in particular, are those points as they're developed in the paper in particular. So one is a question I would like to see expanded a little more. There's a lot of brevity as you get to sort of talking about the filters and what the specifics wind up looking like, and the paper's long already, so I get it. But on the other hand, it'd be useful to know more about how practices can be contested, or what counts as evidence of contestation of practices. In your oral remarks, you said that it'd be a concern if there were objections to practices over time. But that's not really what appears very much in the paper. Instead, the paper tends to emphasize concerns about to what degree do we see practices changing across time? To what degree do we see multiple institutions adopting a practice? So is the president adopt the practice as well as Congress adopting the practice, for example? And that's good evidence about sort of that kind of uniformity that we get. But one thing that was sort of in the back of my mind, I was reading the paper because it's timely, in part, although not the kind of practice that you quite have in mind here, is thinking about war powers context, for example, where maybe the president's asserting a lot of stuff and Congress says, wait a second, that seems to be a problem. But Congress doesn't have really good ways of expressing its contestation in ways that were often sort of seen as the key indices that we'd be looking for in these traditional modes of practice. So what kinds of expressions of contestation could Congress make in this context that courts would take note of and say, oh, well, that seems to be a problem. And likewise, we can imagine sort of partisan differences emerging where Republicans all line up, even in Congress, for example, and say, yeah, this is fine. And then you have Democrats, on the other hand, objecting. So you get a sort of partisan contestation about a practice. And so when we're thinking about how uniform is the practice, how much consensus is there behind the practice, does it need to be a bipartisan consensus, or is it sufficient that the sort of partisans who happen to be in charge a lot of the time, which, for example, I tend to think about some of my work on this, thinking about the Jacksonians, for example. So Jacksonians developed a set of understandings about the Constitution, and one thing that helped the Jacksonians was they mostly controlled the government for a long period of time. And the Whigs constantly complained about it and objected to it. So you didn't have a bipartisan consensus about a lot of the practices the Jacksonians had embraced as being constitutionally required or consistent with the Constitution in general. But the Whigs didn't really have a good mechanism for lodging their objections or for altering the practice because they couldn't control the government in any meaningful way or particular institutions of the government in particular ways. So if you were looking at that, if you're from a judicial perspective in hindsight, how would you assess that kind of situation where you say, well, the Whigs keep objecting, but on the other hand, they keep losing, so who cares? Or is that kind of contestation significant in some fashion that we ought to be taking into account if we're trying to approach this in the way judges were approaching here? And finally, I would just note, one thing that sort of the paper emphasizes is this idea that unlike the sort of some of the liquidation arguments or my construction arguments, is to what degree is practice being used to fill out ambiguity in the text as opposed to this is evidence of original meaning of the text, which I think it often is. But to what degree might we think that what practice is doing is, as Madison sort of suggested, maybe a contestable interpretation of what Madison's thinking of exactly, and he's unclear. But there's genuine ambiguity, uncertainty about what the text means, and we're just going to take this as settling the situation, not necessarily illuminating the situation as such. One issue for using primarily judicial evidence on this front, I think, is to what degree do we expect judges to ever admit there's ambiguity about the constitutional text or even statutory text in other contexts when they're looking at this? Or they're always going to say, look, I'm just telling you what this thing means. And no one really questions it. It's all very clear. So you people ought to go along with it. And that's what they think. And that's part of their rhetoric that judges use for authoritative purposes. They're never going to just say, well, the Constitution is really unclear and it's ambiguous, but we're going to take this practice as sort of settling it, and so it's resolved. That's a feature of judicial rhetoric and how they play out rather than a conceptual feature of the universe. And so is the fact that judges are often pitching this as we're just interpreting original meaning a strategic rhetorical device rather than conceptually true. And how should we think about that as scholars, for example? But the other point about this is how does this reconcile with some of Jonathan's points? So y'all cite some of the same cases in some points, and Jonathan's paper emphasizes some of those cases say, there's ambiguity here, and how do we resolve the ambiguity? Well, we'll turn to practice, and you say, oh, no one ever talks about ambiguity. So I think y'all need to talk a little more about how to interpret some of these cases and resolve some of this question about what exactly some of these cases are doing and how practice is being utilized relative to ambiguity.
Professor.
Yeah, thank you very much. That's very, very helpful. I'll just hit on a few of these points. I take the point that courts are not the only source of individuals who are doing this kind of interpretation. I've done some work, mostly by looking at Madison, because he talks most about this outside of the judicial context, to try to figure out whether there are meaningful differences between what courts are doing. So it's a future paper. Obviously can't fit all into this paper. But I do plan on doing more of that. I think it'll be interesting to see At least my reading of Madison is that he's doing the same thing that the courts are doing. So I have not found any meaningful difference between those two things yet, but there's more work to do there. On what counts as contestation, there's a really interesting topic to explore. One of the problems is there just aren't that many cases where courts actually say we're not going to apply a presumption of good faith. They're overwhelmingly saying, well, everyone's gone along with this, so they probably all believed it. There's just a small universe of cases where they actually dig into that, but I think trying to figure that out is complicated and probably could use more development. So I will stop there, but thank you very much.
Thank you. Katherine?
Great. Thank you. So if Greg was the milk at the back of the grocery store, I don't know what I am. I guess whatever's out behind the grocery store. All right, so since 1908, the primary way to challenge a state law as unconstitutional and to get a federal court to issue an injunction preventing the state from enforcing that law has been through the procedure that the Supreme Court approved in the case Ex Parte Young. Recently, states have been trying to get around Ex Parte Young by implementing laws that burden and even prohibit constitutionally protected conduct while making it impossible to go to federal court to prevent the law's enforcement. So the most famous instance comes from Texas's Senate bill, or SB 8, in 2021. So I'm sure you all remember SB 8, but just briefly, it prohibited abortions earlier in pregnancy than Roe and Casey allowed, and this was before Dobbs, so Roe and Casey were still good law. It involved very high penalties, and it only permitted private enforcement, meaning private individuals bringing civil suits against people who allegedly violated the law. So the private enforcement part is the part that was meant to get around Young. Young says that you can get an injunction against the executive officials who are responsible for enforcing a law. And so Texas said, fine, we just won't have executive officials enforce this law. We'll just have regular people enforce it. So all this led to a challenge to SB 8 called Whole Woman's Health versus Jackson, which ended up in the Supreme Court in late 2021. The plaintiffs were abortion providers and abortion rights activists, and there was a whole list of defendants. It was as if the plaintiffs were trying to sue everyone they could think of to sue to try to make it so that Texas, couldn't enforce this law. So they sued Attorney General Ken Paxton. They sued a state court judge and a state court clerk with plans to turn those into defendant classes. They sued state licensing officials, like officials who were in charge of state boards that were involved with healthcare licensing. And they sued a private individual who had made threats about bringing private suits under SB 8. So all of those were unsuccessful. The Supreme Court said that they couldn't sue any of those parties because those parties didn't have enforcement authority under Young. They weren't young, proper young plaintiffs, except the Supreme Court did say they could proceed against the state licensing officials under Young because the Supreme Court thought that there was some residual authority for the licensing officials to enforce SB 8 in granting licenses and things like that. The case then went back on remand to the Fifth Circuit, which sent it to on certified question to the Texas Supreme Court, and the Texas Supreme Court said, no, the US Supreme Court misread Texas law. Those licensing officials don't have any authority to enforce this law, and so the case essentially ended there. So you can see how this could put some constitutional rights in jeopardy where people can't enforce them in federal court through Young. And it's not just about abortion rights, it's about all constitutional rights, or at least unpopular rights. So rights that people would be hesitant to exercise in the face of prohibitions for fear that judges might not back them up, for fear that judges might say, if an enforcement suit is brought against them, judges might say, you didn't have this constitutional right in the first place. So we've seen what some people call bounty laws gain in popularity since SB 8 was passed, both in and beyond the abortion context. Some examples are other states, passing similar abortion restrictions before Dobbs came down. California passed a gun control law that was modeled on Dobbs. Florida has a Stop Woke Act, which gives parents a cause of action to challenge schools teaching so-called critical race theory and other controversial topics. but that one also does include executive enforcement. So as the challengers put it in the Jackson case, churches and religious leaders could be hauled into far-flung courts to defend their religious practices because someone somewhere disagrees with them. Same-sex couples could be sued by neighbors because they obtained a marriage license. So I started thinking, why can't plaintiffs just sue the state itself in these situations, right? So in Jackson, the plaintiffs sued everyone they could think of, all these Texas officials, but they didn't sue Texas itself. So obviously the answer is state sovereign immunity, right? But Young is often seen as an exception to state sovereign immunity, which made me wonder, why couldn't the exception to state sovereign immunity encompass the state itself? So courts understand Young as allowing plaintiffs to sue government officials in their official capacities, which means that those suits are considered to be suits against the state itself anyway, just, people haven't been able to bring them against states in the names of states. So that led me to dig into Young, how it's been understood in the century plus since the Supreme Court decided it, and whether it could support suits against states in their own names. So courts and scholars have established three main approaches to Young. The first is what I call the structural approach, and then there's also a historical approach, which is more recent, and I identify two different versions of that historical approach. The first I call the revisionist version, and the second the restorationist version. So I'll talk about each of these approaches in turn. So the structural approach treats Young relief as a necessary component of structural constitutional law, essentially as maintaining both the supremacy of federal law and the availability of judicial review. And this approach sees Young relief as indispensable to the rule of law itself and as being adaptable to achieve those ends. So there are multiple ways that Young doctrine has expanded over time to keep government officials within constitutional bounds. A good example comes from a case called Bantam Books in 1963. So in this case, the Supreme Court allowed a Young suit to proceed against the state board in Rhode Island. The board was threatening to report publishers and other makers of smutty books and magazines to the Attorney General, even though the board itself had no actual enforcement authority. So the Supreme Court allowed this case to proceed under Young and said it's not as if this were not regulation by the state of Rhode Island. Chief Justice Roberts also adopted a structuralist understanding of Young in his separate opinion in Jackson. So he said that the principles underlying Young would authorize expanding relief he was arguing against the court officials in the Jackson case, who play an essential role in the SB 8 scheme, he said, and he says that any novelty in this remedy is a direct result of the novelty of Texas's scheme. So looking more at the principles that underlie Young. So because of this approach's inherent adaptability to preserve the rule of law against creative attempts to evade judicial review, I think that it should support suits against states in the private enforcement context to the extent that those suits would be reasonably necessary to attain relief. So turning to the historical approach, the structural approach dominated Young doctrine for several decades before the court's more recent turn toward originalism and now history and tradition. And with those shifts has come a greater focus on the historical background underlying Young and arguably limiting Young relief. The first version of the historical approach comes from Professor John Harrison, who will hopefully tell me if I'm getting any of this wrong. Although I did get the baby from the king cake this morning, which apparently makes me queen for the day and means he has to be nice to me. So I call Professor Harrison's version the revisionist version because it seeks to revise and limit ideas about Young's expansive capabilities, especially regarding affirmative and structural injunctions, which are not at issue in this area. We're really talking about the traditional kind of negative injunction that says you can't enforce a law. So Professor Harrison argues that Young relief is a variation on the anti-suit injunction, which allowed plaintiffs in equity to assert legal positions that would have been defenses at law. It allowed them to do that in an affirmative posture. So in the Young context, parties who would have been defendants in an enforcement proceeding at law can assert the defense of unconstitutionality prospectively in equity. So if the anti-suit theory is right, Professor Harrison argues, Young doesn't provide an exception from sovereign immunity at all because sovereign immunity doesn't apply to defenses. If the state is moving against you, you can assert unconstitutionality as a defense, and sovereign immunity isn't going to stop you from doing that. CASA, you guys know CASA, the case that the Supreme Court decided against universal injunctions earlier this year. It wasn't a Young case itself, but it debated what the history and tradition method could mean for Young, and it suggested that the anti-suit model could provide justification for Young relief. So in terms of applying this theory to suits against states, I think it leads pretty directly to the possibility of Young suits against states themselves in the private enforcement context, at least to the extent that you see the plaintiffs in the private enforcement context in SB 8 type suits as acting as delegates of state authority. So the next version of the historical approach I call the restorationist version. This comes from work that Professor Jim Fander from Northwestern has done. And Fander argues that to understand Young, we shouldn't just look to the history of equity, but we also need to look to the history of law. In particular, he points to three so-called administrative writs, the writs of mandamus, certiorari, and prohibition, and talks about how they crossed over from common law into American equity and were sort of absorbed into broad injunctions during the course of the 19th century. And so he argues that that tradition supports broad affirmative relief, which is why I call it the restorationist approach. I'll skip over the example that I have here for the sake of brevity, since it's always hard to discuss the Virginia coupon cases concisely. But in terms of applying this theory to states, this approach should support suits against states in the private enforcement context, I think, for at least two reasons. The first is like the structural approach because it has a tradition of adaptability. The second is because the administrative writs had roots as public actions that were brought in the name of the tribunal's sovereign. So here, that would be the United States itself, which states have no sovereign immunity against. I'm running short on time, so I'll just say that that's sort of the affirmative argument. It leaves at least two sets of questions. One is about the scope and operation of injunctions against states, and the other is about the limits of this theory. How can it work without potentially subjecting states to suit for all private causes of action that are allowed under state law? I would just say that in terms of the first set of questions, it's relatively common for federal courts to issue injunctions against states, including in the constitutional context where the United States brings suits. So there's a whole framework for how it's done and how it's implemented against state agents, who I think here would include judges who would be potentially rendering judgment in SB 8 type cases. For limits on this theory of state suability, I think it should apply only for private enforcement schemes that sound in a tradition of public, not private law, which I can talk about more if that'd be helpful, only where necessary to attain judicial relief in light of alternative processes, and that courts should start by awarding declaratory judgments and then award injunctions against states only if the declaratory judgments prove inadequate. So with that, I will turn it over to Professor Harrison.
Thank you. Here is the way in which I can be a substitute for Richard Epstein, although of course no one can be a substitute for Richard Epstein, which is both he and I are sufficiently senior now that compared to us, someone who is a full professor and runs a center is nevertheless qualified to be a junior scholar. So I'm doing what I can. I want to talk about the approach that Professor Crocker talks about to the problem of distributed enforcement, bounty enforcement, whatever it should be called, with that Texas law SB 8 as leading example. I find the subject extremely interesting, in part because the architects of that mode of proceeding seem to have thought very seriously about how the American constitutional and judicial system works, and came up with a way to get around some of the familiar ways in which that system works by understanding the premises on which judicial review is based. The first such premise is that in a lot of situations, including what we call individual rights, the way the Constitution works is not by imposing duties on governments, the way you might think of international law as imposing duties on states, but rather by entering into the content of the legal system and causing some purported state enactments to be invalid, not to be law. And that means that aspect of the legal system has consequences about, well, what kind of enforcement is possible. The next piece of the system that something like SB 8 is designed to exploit, and this may be the most important part of it, is that at least in the federal courts under Article 3, litigation is adversarial. That is to say, somebody has to sue somebody else. And it is not possible, as it's sometimes said, simply to sue a law. No, there has to be a party on the other side. And the way the SB 8 systems work is, well, in an essentially, what I think of as an essentially defensive proceeding, like ex parte Young, someone who is a potential defendant, wants to sue some potential plaintiff and needs to find a potential plaintiff. The way the SB 8 type systems are set up is, well, you don't know who the potential plaintiff is going to be until that person sues. That's why I called it distributed enforcement. And the way SB 8 works is to take advantage of the fact that Article 3 at least requires that there be a defendant. The third part of the way those systems work, which may not be entirely obvious, but I think is quite important, it's both important for the way the systems work and it's important as a feature of the American constitutional system, is that states don't have to have federal separation of powers. And in particular, the states don't have to follow the principle, whether in the federal system it's properly attributed to Article 3, or as I think, Article 2, but the Supreme Court says Article 3. States don't have to follow the principle that you might say the government owns public rights. To be a little more concrete, states don't have to follow the principle that only the government is allowed to enforce the pure duty to comply with the law. And the government, in the federal system, the government alone can enforce the pure duty to comply with the law without having suffered or being threatened with any additional harm. But that's true in the federal system. States don't have to respect that. States can do whatever they want with who can bring an action based purely on the fact that somebody else has violated the law. So those are the features of the system that SB 8 exploits. And Professor Crocker says, even given those assumptions, it is possible to have, at least this is how I'm interpreting her claims, even given those assumptions, it is nevertheless possible to identify a proper defendant consistent with the idea that litigation under Article 3 is adversarial. It is the state. And I think this is part of her claim, and I'm going to say this is important. First, that's okay given sovereign immunity because this is an essentially defensive proceeding. And as she says, as I certainly agree, assertion of a defense against a state is not inconsistent with sovereign immunity. Trying to get money out of the state treasury is inconsistent with sovereign immunity. But saying, see, for example, the Virginia coupon cases and the very clever system that the people who designed the coupons came up with to make it possible for private people to litigate against the state, they made it possible for them to do so in a defensive posture. And as long as the private person is litigating in a defensive posture, no problem with sovereign immunity. I agree with that. And so yes, a suit against the state will be consistent with sovereign immunity, given that it remains essentially defensive. It is by someone who is a potential defendant saying, I want to assert my defense now. Okay, does it work otherwise? Well, I think a crucial step in what Professor Crocker contemplates is that after a successful suit against the state, those private people who might bring suit pursuant to one of these enforcement systems would be collaterally bound, would be subject to issue preclusion on the grounds that, well, you are sufficiently closely connected to the state that the judgment against the state also can be used against you if you now sue, even though at the time nobody knew who you were. The theory of issue preclusion that Professor Crocker talks about that I'm not persuaded by is a standard feature of injunctions. Injunctions apply to the defendant and the defendant's agents and people acting under the defendant. Now, one of the things we've learned from Chief Justice Roberts is that the law of agency is what the Supreme Court of the United States says it is, see Hollingsworth against Virginia, and it has something to do with the restatement of agency, no matter what the law of any state might say. I think that even given a fairly loose approach to principles of agency, I did not find that part of the system worked. I don't think it's really plausible to say that those potential private plaintiffs are agents of the state, even again taking a fairly loose approach to federal preclusion law, which, because it would be a federal judgment, would then be applicable in state courts for this reason. The whole point of a system like that is not to have any state control over whether the private people sue or not. What's an agent? An agent is somebody who acts pursuant, under the authority of, on behalf of, and under the control of the principal. The reason that an injunction applies to agents is because otherwise the defendant could get around it by acting through an agent, that is, getting somebody to do what the defendant is being told not to do, getting someone operating under the defendant's orders to contravene the injunction. I think, although I'm still skeptical of this for a reason that I think is really interesting, I think that the better theory of preclusion would be not agency on the part of those potential private plaintiffs, but rather that they are in privity of a state with the state. That is to say, they are attempting to assert the state's right. The reason I'm skeptical of that is precisely because these SB8 systems are based on the assumption that rules about who owns what rights that apply at the federal level do not apply to the states. And that if a state says this is a private right, well, then it's a private right. And the private person is neither an agent of the state nor asserting the state's right. The private person is asserting the private person's own right. The one way around this, I think, that does work probably is legislation by Congress under one of the enforcement clauses of the Reconstruction Amendments. I think that raises really interesting questions too. The last thing I'll say is I think, but I haven't thought this through as much as I'd like to, I think that when Congress acts under Section 5, at least when it authorizes suits by the United States, it can treat a State of the Union, the relationship between a State of the Union and federal law, like the relationship between a sovereign and international law, and say that the sovereign has certain duties and enforce those duties. Whereas in the absence of Section 5 legislation, I think, again, to get back to the first feature of SB8 type systems, the federal Constitution doesn't operate on the states like that, or on their employees, agents, and so forth, and officers. It does not impose duties. Rather, it creates criteria for validity that determine what is valid and what is invalid state law, and those criteria of validity then feed into whatever is the system for applying the law. I think there's a real possibility that Congress, pursuant to one of the enforcement clauses, can change that relationship, at least if the plaintiff is going to be the United States. I think that if there is a counter to the SB8 distributed enforcement type system, it has to take the form of enforcement clause legislation.
Brief response?
Yeah, thank you. So this gives me a lot to think about, obviously. I would just say I do try to anticipate this argument that that an injunction wouldn't bind potential private plaintiffs in the paper, and my argument is that even if it doesn't bind them, it should still bind the state judges who you would bring a private enforcement action before, and that at the very least they shouldn't be able to, at the end of the day, rule in favor of these private plaintiffs. Then you have to get into what is state action. Are the judges engaged in state action? I think they are. Professor Harrison might not think they are. I'm not totally sure. I would love to talk with him more about it offline because I know we're over time, but that's sort of my response to that main part of his comments, but super helpful things to think about.
I think we are over time, right? So I need to, unfortunately not going to be able to.
We should probably wrap it.
Yeah.
He has one really urgent comment. I think actually people can just give comments.
Okay. All right.
By email, so, yeah.
All right. Well, thank you all. Thank you so much to our panelists.